So let's get on with our topic for today. And it's not the most exciting topic. I'll apologize in advance, but legal descriptions, easements, rights of way, it's pretty dry stuff, but we're going to get through it because it's important for you to just know what you have to know and what you have to do. So we're going to get through it today. I'm going to skip through our areas of practice and our offices. You know that. Please do tune in to the podcast that I'm doing. We just yesterday we did our 65th podcast with Tim Hudak was our guest. So Tim Hudak, for those of you that may not remember, was the head of the Progressive Conservative Party in Ontario before Doug Ford. And then after he left politics, after 21 years or something in politics, he became the head of the Ontario Real Estate Association. So he's your guy. He's the head of AREA, and some fabulous information that he shared with us yesterday. So that'll be coming out in the next few days. So please tune into our podcast anywhere you can watch it on our YouTube channel. Just search for Kormans. You can listen to it anywhere you can listen to a podcast. David and David on real estate. So let's go on. What do you have to know about legal descriptions? Legal descriptions can be described in a couple different ways. It's usually described as lots and blocks, which typically you'd think of it as a subdivision, sort of the easiest thing. It might be lot one on plan M something or other with a number, and that's pretty simple description. The tougher descriptions are sort of the older descriptions that we still come across in a lot of properties when they were described with meets and bounds. And that's generally used for properties that aren't subdivision properties in the normal sense. And those are really complicated to understand. Those are described usually from a starting point somewhere that a surveyor put a metal spike or something in the ground. And it says from this starting point, then you go so many yards or so many feet. And now you might get it in meters, but it's usually so many feet or yards, southwesterly, a distance of so many feet, and then you to a point, and then you go easterly or southeasterly to another point, and you're tracing it out and drawing it out. And they're very complicated types of descriptions to follow. But we got to deal with what we got to deal with. So the important thing is you've got to accurately put down your legal descriptions in your agreement of purchase and sale. And sometimes it's as simple as a lot on a plan, or a lot or a block on a plan. It's really short and easy to fill in. Sometimes it goes on for pages. So if it is a long legal description and it might contain easements and rights of way in it, I always encourage everybody to put the full legal description in your agreement of purchase and sale. So if it's a long one and you've got to just say, see schedule and just put it on a schedule, then do it. Don't try and create a short form of a legal description yourself and leave something out that might be critical to it. So just keep that in mind. Now, every property in Ontario is now given a property identification number, which we call a PIN. So every title to every property has a designated PIN. So we look up that PIN and then we get a legal description from it. So it's a 9-digit electronic identification number that's specific to an individual property. So that's not the legal description. So you can't just say the legal description and then just put down the 9-digit number, but because the legal description is going to be something else. It's going to be these lots and blocks or these meets and bound descriptions, but every property has this designated PIN. So if you have the PIN, I encourage you to include that as part of your legal description. So you have your 9-digit PIN number, and that's the first thing. And then the legal description is what follows. And that way, anybody looking up the title can look at it, because you search it by way of the PINs first to find it. And then you've got to go through the detailed legal description. So part of a legal description is sometimes includes easements. Okay, and sometimes you hear the terms easements, sometimes you hear rights of way. They're really interchangeable terms. There are different types of easements in Ontario. So there's what's called a gross easement, which is a right for someone to use your property that's given to an individual. And there are legal permissions that get attached to the deed of your property. This goes right into the legal description that you're granting, that an individual's been granted a right to use part of your property or part of your property. Appurtenant easements are a little bit different. It's a right over use of your property for the benefit of adjoining landowners. It doesn't matter who owns it, but I'm granting the right to anybody that owns the land beside me to go across my property or to cross my driveway or to access my a part of my property for some specific purpose. So again, this is a legal permission that's registered on title, and it's part of the deed to my property that I own lot 1 on this plan, and I've granted the right to the owner of lot 2 beside me to go across my whole property or a portion of my property for some specific purpose. And it's registered like that right on title. Now, when easements are created, they're created in a few different ways. It can be an express grant where the owner is granting the privilege of use to another for a specific purpose. And a lot of times the purpose itself is described specifically in these documents. Like, for example, in a lot of the current subdivision homes, the lots are really close together. You might have 3 feet or a meter or something between the lots. So a lot of times there's an easement created that, and lots of times a mutual easement that each of the neighbors are granting the right to go on that area between their homes for the purpose of maintaining their own home. Because if someone, let's just say, for example, that it's a 3-foot area and 2 feet might belong to one neighbor and 1 foot belongs legally to the other neighbor. But if either of them has to put up a ladder just to maintain their eaves troughs or to fix a window or something on that side, they have to have the right of way of the other owner. That the permission has to be granted in order for them to do that. So an easement sometimes is created for a simple purpose like that, and it'll be described that way, that it's for maintenance purposes. Other easements might be described as a right of way for someone to pass through to get somewhere. Easy examples of that, you see that a lot of times in cottage type properties, where someone might be granted access to get to their property by a right of way, or there might be access to a lake or a river through someone else's property. So that's an express grant. It's a right of way for a specific purpose. Now these don't create ownership interests. Like if someone is granted an easement or a right of way, they don't own that area, but they have a legal right to use that. So, and sometimes this is done on private easements, sometimes it's public easements for different ways. So public right-of-way example is a road or path that's going through someone's land in order to access a public area. A private right-of-way would allow a neighbor to go through your property to make the access to their property easier. And we don't typically see this in the middle of Toronto, although there are rights-of-way, there's mutual driveways and there's things like that. But so there's some of that in the city, especially in the older properties. You don't see it much on the newer properties, but you certainly see it when you get into rural properties quite a bit. So express grants is an example would be a deed granting a person the right of way to use another person's road, and it'll be described right in the deed. So it'll say together with a right of way over the existing road to access and egress the property. So that would be together with, because that would be the person that's been given the access on their title. They own lot 2, for example, together with a right of way over another part of a property in order to get to their property. So if that property is then going to be transferred, there's a subsequent deed, then, and the person has granted that right of way, so it has to be described that their property is now subject to a right of way over that. So it's an owner granting access rights to another to pass over their lands. So, and again, like I said, we see this a lot in rural properties, cottage properties, and sometimes it's access to roads. There's private roads. Sometimes those roads are owned not by a bunch of cottages, might be owned by one specific cottage owner, and they've granted other neighboring cottages the right to go across that road. So that road is owned by that one owner, but they've granted rights to the neighboring cottages. So that owner, when he grants it, their property is now going to be subject to that right of way. The parties that are getting the benefit of that, their property is going to say, we own this cottage property together with the right to go over John Smith's private road in order to access our properties. We really want those descriptions on both properties. Okay. Similarly, waterfront properties, you see this all the time. Some properties are landlocked. Some cottage type properties are landlocked. They have no access to water unless they go across somebody else's property or a portion of someone else's property to access the shorefront. So we see that there all the time. So a different type of easement is called an easement by prescription. And you've probably had, I've come across this. Sometimes you get stories out there, and this is something that's created through adverse possession or what's called squatter's rights. So an example of that could be if an owner builds a fence that's really closed off part of their neighbor's yard. They built it in the wrong place. It's not on the neighbor's, it's not on the lot line between the two properties, but now they've put up a fence that maybe it's a foot or two inside that neighbor's lot line. So if that goes uncontested for an extended period of time, the owner of the fence who built the fence in the wrong place could argue that that easement exists and it can't be taken away. The burden of proof is always going to rest with the person claiming that. So, and this is really an encroachment on the neighbor's property. They never really had a right to it, but if it was never contested, and then all of a sudden the owner says, oh, you built the fence in the wrong place and we want to put it back. The party that's had the benefit of that, even though they were in the wrong putting it up in the first place, they might be able to argue that encroachment on the neighbor's property has now created an easement. And they should have a continuing right to use that land because historically they have used those lands. And that's a little bit different. You've probably heard adverse possession or squatter's rights in terms of that homeowner claiming that area that I now fenced in, it now belongs to me, because that's a different argument they can make for the same type of purposes, that I've had exclusive rights, exclusive use to that area, even though it wasn't originally mine, but 10, 15 years has gone by. The neighbors that really own that strip of land has never argued for it. They've never accessed it. They can't even access it because I got a fence up there, and they can argue that now belongs to that owner. But that's a different issue from today's topic, where we're really focusing, has it created an easement? There's a third type of easement, which is an easement by implication. So here you would have two adjacent property owners, and a typical example, this is row houses that have a party wall between the two neighbors. So this easement is created by necessity because they're sharing this party wall. And sometimes the owners have to enter into a party wall agreement because both parties have to maintain it. They have to maintain the respective sides. So sometimes you'll see that type of an easement, which is by implication in those type of situations. So a fourth one is an easement by statute. And this is for public purposes, like Public Service in Ontario can create easements to ensure that they get access to their facilities and equipment. You see this for utility purposes all the time, to bury cables or other, wiring, sewage pipes, things like that, drainage issues, easements for drainage and sewers. So the government has the right to create those easements by statute, and sometimes another term is used, and it's easements and gross, it's interchangeable, but that's the public right to create easements so they can access their facilities and equipment. So an easement, like I mentioned before, doesn't create an ownership interest. It grants the use of part of the property. It doesn't transfer the ownership. Okay, so the owner, it's themselves, the original owner is still responsible for property taxes on the easement part of the property. They're generally still responsible to maintain the easement lands as well. Now, sometimes there's a negotiation. There can be an agreement created between the actual owner of the property and the parties that are getting the benefit of the easement to share some of those costs, or they agree that they're going to be responsible for the maintenance of it. So that's always that can be done by way of negotiation, entering into an agreement. But in terms of basic principles, the original owner remains the owner. They're not conveying part of their lands. They're not creating a legal ownership interest, but they are granting a use of the property for certain specified, sometimes very limited purposes. So they're responsible for all the costs associated with that, unless they negotiate some other agreement to pass some of those costs on or share those costs. So any easements that are created, it have to get registered. The land registry office keeps these registered. There's a process to go through to register easements, to have proper descriptions of these easements. And if they're not described properly, they're not going to be enforceable. So, most of the time when an easement is being created these days, we're not using meets and bounds type of descriptions. We're getting a surveyor to create a reference plan that will describe those easements. You see it, in the older documents, you will see meets and bounds descriptions, but anybody that's doing an easement these days, if you're creating one, you have a reference plan drawn up by a licensed surveyor that'll show, here's lot 1 and here's lot 2. And the owner of lot 1 is now creating a strip of land which is part of lot 1. So we're dividing lot 1, for example, we'll say lot 1 is now we're creating part 1 on lot 1, and we're creating part 2. And the reference plan will show these parts, part 1 and part 2. And part 1 would be everything, like the whole lot, except for whatever the strip of land that we're creating and calling part 2. And we want to get that registered on title. So then when we create the easement, we're describing it that the owner of lot 1 is granting an easement or a right of way in favor of the owner of lot 2, just for this part 2 on this reference plan. So they have the right to go on this strip of land that's just legally described now as part 2 on a reference plan that's now registered in the registry office. So anyways, there's procedures to do this. You guys are never going to be involved in creating these things or doing these things. This is the job of lawyers, and sometimes planners get involved, and we need a surveyor to do this. But you have to just understand the process we have to go through, and just hopefully understand what you're looking at when you're seeing these registered documents, and why that happens that way, and why we have these reference plans and then create these different parts on reference plans. So it's really the lawyer's responsibility for creating this, searching property, checking these things out, checking the title on adjacent properties to see that the rights of way or easements are recorded there properly as well. Now, there's a different type of grant of use of property, and I just want to make this point. There's a difference between a license to use someone's land, a lease to use someone's land or part of someone's land, and an easement. So a license grants an interest to go over the whole piece of the property, all the land, or maybe it's for a piece of the land for a specific period of time. I'm granting you the right to use this property for a specific period of time. That's different from a lease, which is another form of license, because it's granting a use, but it's an exclusive use for a stipulated length of time as well. Okay, now an easement's a little different from both of those, because those are really license, lease are both forms of licenses. But once you grant an easement, that easement exists until it is terminated. It's not for a specific piece of time like you would have in a license situation that would just run out and it's over. When an easement's granted, it's indefinite until there's a process to terminate, or it specifies that it'll be terminated, or there's some agreement down the road that it's going to be terminated. So slight difference in it. So we're always taking a look: is this a license? Is it a lease? Is it an easement? How is it described one way or the other? So when you're using your standard form agreement of purchase and sale, And I know sometimes we don't look at what those documents actually say. We all tend to sort of skip over the fine print and just focus on filling in the blanks and attaching schedules with other provisions in it and conditions and things like that. But there is protection right in the standard area form agreement purchase sale that protects buyers from any undisclosed easements. So if you take a look at clause 10 in a standard form agreement purchase and sale, it basically has a provision in there that if a lawyer discovers an easement on or before the requisition date, the buyer can object to it and say, I don't want to take that property because it's subject to this easement. And the requisition date is the title search date. So the clause says that the buyer has until a certain date that you're completing in order to do their title search and blah, blah, blah. So that date is the requisition date. So if when we're doing our title search, we see there's an easement that was not disclosed, it was not described properly in the agreement of purchase and sale, that gives the buyer the right to say, I want to terminate the deal, or I want the seller to get rid of that easement because it wasn't disclosed. And you may or may not be able to get rid of it, or it might be extremely costly process to get rid of that easement. So it could really have a serious effect and blow up your deal, which is why I go back to, I'm going to repeat that point, that it's really important for you to have a proper full description in your agreement of purchase and sale, because if you have a full description of agreement for sale, then you are disclosing the easement. You are disclosing that the property might be subject to a right of way, or maybe it has the benefit of an easement that is together with a right of way. But if it's in your legal description, the argument can't be made later on that it wasn't disclosed. Now, that clause 10 also excludes objections to minor easements for public services and utilities. So I mentioned before that the government has the right to create easements for services and utilities. So a buyer, when we search title and says, oh, there's an easement in favor of hydro because they've got cables overhead, or they got cables buried, or there's some sewers on part of the property, or something like that, a buyer can't get out of the deal because they've discovered that there is those type of easements on title to the property. The property is subject to that. The buyer can't object to that. They have to take title subject to those services and utilities, which generally isn't an issue because they want the benefit of those services and utilities. Okay, but take a look when you get a chance to clause 10, because you'll see that's the protection of the buyer, but it only works if you're providing proper legal descriptions in your agreement of purchase and sale. So a question that I get asked all the time, and this is an issue, like, how do easements affect property values? So if you discover that a property is subject to an easement, does that affect the property value? If you find out that the property has the benefit of an easement or a right of way, does that affect the property value? So it could go both ways. An argument can be made that an easement adds value to the property as much as you can argue that it decreases the value, because if you get the benefit of an easement, you have additional rights, you have access rights, you have things like that. So it's not to, oh, I found an easement and you know that therefore there's no value here. So no, you have to look at the specific fact situation. So a property subject needs doesn't necessarily decrease the value. So we have to look at each situation. It actually could be increasing the value. If you're giving an easement to your neighbor, sometimes that's not a negative thing on your property. It can be a positive thing in certain situations. So it's tough to go back and say, oh, we didn't know about easement, therefore it decreases the value. No, you know, your neighbor's use of the property, if they're adhering to their easements, sometimes it adds value to the whole neighborhood, that these mutual rights of way or easements have been created, and you can easily argue that it can increase value as opposed to decrease value of a property. So that's all I really wanted to talk about in terms of easements and everything. Now, I know Dawn wanted me to, before I get into surveys and title insurance, I think she did want me to comment on potholes and things like that. And, you know, so all that is that's it's in a condominium situation. And the first thing I could tell you to do, if you think you're dealing with a pottle, you should be using the right form of agreement of purchase and sale. Okay, because you should all know there are different forms of standard AREA forms of agreement of purchase and sale. One for standard residential properties. There's a different form if it's a condominium, and there's a different form if it's a common element condominium or has what these things like pottles, et cetera, in it. So make sure, first of all, that you're using the right one. So these are shared elements where, and sometimes like the pottle situation or a common element situation for that type of form, it's generally a situation where you have a project that it might be look like townhomes or something like that oftentimes, but they're actually condominiums, but they're condominiums, or they are more typically owned properties, freehold ownership of the residential property to be living in, but they share certain common elements. These are exterior common elements. So they're sharing roadways, laneways, parking garage access, things like that. So it gets created through these common element condominiums. And so we're searching title to see that they're the actual ownership. They're going to transfer freehold ownership to the residential unit, but they're also have an interest in the common elements because everybody in the project is sharing these roadways, for example, or laneways, and there's shared costs involved with that. Just the same way that if you're in a high-rise condominium, there's certain elements that are considered common elements that you're sharing as well. Okay, so in a high-rise condominium, you're sharing the lobby space, the elevators, the hallways, the swimming pool, things like that. So those are more typical things. But on these other projects where these where there's exterior common elements, it's that type of thing. It's usually roadways or laneways, maybe access to parking garages, maybe there's a little bit of parkland in there. So those all have to be maintained as well. So they're not big budget items like elevators and roofs and underground parking garages to be repaired, but there's still maintenance and access through those areas that have to be described. So there's a common element condominium corporation is created, it's described that way. And these things have to be described properly in your agreement of purchase and sale, which is sort of a long-winded answer for probably a bit of a short answer. But you sort of have two different descriptions that you have to have. One is a description of the residential property that you're buying, but they are also an interest in this common element corporation that's being created as well. And because it's a common element corporation and it's really a condominium, we have to get a status certificate and we have to review that as well. So make sure that you're using the right form of agreement of purchase and sale, and make sure you've got conditions that it's conditional upon reviewing the status certificate for the common element portion of that. So Dawn, I hope that covers what you were looking for with that.
I think so. Ruby, did you have anything else you wanted added to that?
No, also detached properties can have, common element.
Yeah, well, these are detached properties. These are freehold ownership of the residential property. So we're doing a search and we're describing that there, but those owners also have a shared interest in this common element condominium corporation. So it's really two descriptions. Okay, so it's really the description, whatever the legal description is for the detached property, plus they have a shared ownership interest in this common element condominium. So we need both descriptions on there. Okay.
Sorry, I thought you were just referring to townhomes.
No, sometimes you see it in townhome type of projects, but they're not condo townhomes, they're freehold townhomes. But it can also be in a completely detached project as well, with detached homes, but they share these, these laneways or something, and they're all sharing that common element portion and paying for it and maintaining it. And it's administered the same way as a high-rise condominium. You have a board of directors, you have meetings once a year, put a budget together, et cetera, et cetera. So it's the same process that you go through with status certificates and everything. It's all governed by the Condominium Act. So just be careful that, and it starts with making sure you're using the right form. Okay. So just be wary of that. Okay.
Do you know how far back pottles have become a big thing?
Well, I can tell you it goes back about 30 years, and actually a little more than that, but it's a little over 30 years. And I can tell you why. I was involved in, back then, just to age myself a little bit, in creating when they didn't exist. I was involved in a project that sort of created this concept before it was sort of formalized eventually into the Condominium Act. So I don't know if some of you are familiar with the project called Castle Hill, which is lands right around Casa Loma in the heart of the city. So it's a townhome type of complex there. And, and way back in the day when that was being developed, we were creating these townhomes and then a bunch of laneways which needed access to it. And these common element condominiums didn't exist then. So we wanted to find a way to, how are we going to get all the homeowners of these very expensive townhomes to share in these common elements, these laneways, which they had to get through to access their parking garages. And that's where the garbage was going to be. And someone's got to maintain it and someone's got to plow it. And how are we going to make sure they share it? So we created at the time what was called the Castle Hill Neighborhood Association, and registered documents on title where every homeowner had to, you couldn't buy a home without being subject to your obligation to join the Castle Hill Neighborhood Association. And everybody had to pay a certain amount. And we basically, was being governed by appointing officers and directors and putting a budget together and doing all these things. But it was really done as a neighborhood association at the time because the concept of these common element condominiums hadn't been developed yet. And I was doing this at the time at the firm I was at, had one of the leaders in the condominium field at the time. So he was helping me come up with this because he had the expertise in condo. And after we did this and it was working and it still works, he started lobbying the government to sort of get this into the Condominium Act and create these common element condominiums. So I was a little bit part of history. I like to claim a small role in that because I spent night and day trying to figure out how do we make it an obligation for anybody that buys a property to have to share in it. So once it became part of the Condominium Act, it was easy, easier, and that's really what happened. Okay. Now, sometimes in cottage properties, we do see some associations still out there that were created for the same type of purposes. As an owner, a bunch of owners need access through a private road or something to get to their cottage properties or to get to the waterfront. And associations were created, and there's documents and agreements registered on title. And similarly, that anybody that buys one of these properties has to join the association, has to contribute their annual dues to the maintenance of the road and snow plowing and things like that. So we still see some of that in some of these cottage properties. Okay, so I've got about 15 minutes left. So I wanted to go through a little bit on surveys and title insurance because we get these questions all the time. So a survey, you be careful with surveys. Like surveys are supposed to have to be done properly, like anything else. Okay, like an Ontario Land Survey is really providing an opinion on the title and on the legal description of it. So they're on the ground doing measurements and putting iron bars in the ground and measuring with their sophisticated equipment to measure things out. So they disclose, when a surveyor's on there, they're going to be able to disclose structures and things that we wouldn't always see from the naked eye, and they can show us in a graphic form, where the fences are, where the hedges are, where the landscaping is, where the overhead wires are, where the easements and rights of way, and we can actually see that in a document. So it's a really important thing to have a survey. So, but we want to make sure we're getting a proper survey. Surveys have to be prepared by a licensed Ontario land surveyor. They've got to be legible. They've got to be signed, sealed, and dated. it's really important to always take a look at the dates on these surveys too, because it's done at a point in time, and time goes on. Things on the ground factually change and everything. So we always have to figure out, when was the survey dated, when was it made, and is it really still current or up to date? And and how much are we going to rely on it? But it's always good to have a survey. So there's a bunch of benefits in having a survey. And I should say at the outset here that we don't always get surveys on properties. We don't need surveys like we did once upon a time in our industry, because we now have the benefit of title insurance, which I'm going to describe in a few minutes. And one of the advantage of getting a title insurance policy is you can get title. If you're getting a title insurance policy, then you don't need to have a survey in order to close a transaction. You don't need to have an up-to-date survey, because you're going to get title insurance that's going to insure over any issues that would have been disclosed had you gone out and gotten an up-to-date survey. So the title insurance company is saying, don't bother getting a survey. Don't spend $1,500, $2,000 to getting a survey. We'll give you a title insurance policy. And if in the course of that homeowner's ownership, an issue comes up that we would have known about had they had an up-to-date survey, we'll cover that issue. We'll protect them. We'll fix it. We'll pay for all that. So don't bother getting a survey. So for the last 30 years, we've been dealing with projects where we don't need a survey. Lenders don't require a survey, but there still are benefits of getting a survey. So I just want to run through some of those quickly. So if you have a survey, it's giving us correct, up-to-date information, the shape, dimension of the land. It helps us with, when we're doing our title searches, to see the state of title. It shows us the improvements that are on there. It shows us the boundaries. It shows if there's encroachments or right-of-ways or easements created from any of the neighbors, or we have the benefit of it. It'll all be right on the survey. Okay, so it shows us all the warts. And there's sometimes a good thing, sometimes it's a bad thing. So it depends. So it also allows us to verify zoning and setback requirements, because every house, every municipality has certain zoning requirements. So when we see a survey and you say, okay, you can't be more than you can't build the house more than 6 feet from a lot line, the survey will show us whether or not they've complied with that. So pre-title insurance days, we always wanted a survey. We needed an up-to-date survey. We'd be sending it to the municipality to say, hey, here's the survey. Please confirm that it complies with the zoning and the setbacks. And we get a response back. In the title insurance world, we no longer do that. Okay, we're insuring over it with the title insurance policy. If an issue comes up down the road and it turns out there was a problem, the title insurance company will pay to fix it. So if you don't have a survey, there's some potential pitfalls that you always have to be aware of. We could be there, these are just examples. Things have been built on the wrong lot. There's rights of way that sometimes get missing. We don't see where the driveways are located sometimes. We had examples of building partly on a neighbor's lot, whether it's the actual dwelling house or it's a garage or a shed or things like that. We've seen cottages that are built right on top of road allowances. So they're not part of the construction of the cottage, isn't on the actual property. It's built partly onto the road. We've got septic bed issues. We've got swimming pools built partly on neighbors' properties. There's always all kinds of fence and boundary disputes, which creates issues like adverse possession that I was mentioning earlier. Cottage properties, there's always shoreline issues. You see retaining walls that sometimes get shift over time and they're encroaching on neighbors' properties. So we can't see any of these things, or we don't know any of this if we don't have an up-to-date survey. So if you're looking for a survey, you're negotiating an agreement of purchase and sale, there's a couple examples of survey clauses here for you that you should be putting in there. And you should just be careful in making sure you've got proper clauses, because if you want to get a survey, you want the seller to provide a survey, you want to make sure that it's a proper survey, that it's certified by an Ontario land surveyor, and it's showing the current location of all the buildings and structures, additions, fence, etc. That word current is really important. Sometimes it says up to date or current, but that's way better than saying, the seller's just going to provide an existing survey, because that existing survey could be 50 years old. And it may not show the current locations of buildings and structures and fences, et cetera, et cetera. So really be careful what you're asking for. If you're getting an existing survey and it's old, let's say it's a 10-year-old survey, it still might be good, okay? But I would couple that with what I've got in the second clause here, which says, you know, if you're giving us the existing survey, but we also want the seller to give us a declaration, a statutory sworn document on closing, confirming there's been no changes, no additions, and that everything that's shown on that 10-year-old survey still exists today and nothing's changed on it. So at least we would get that. So just be very careful with the language that you're using, okay? And just to repeat, we want to make sure it's a proper survey certified by a land surveyor, and we want to get it current or up to date that discloses everything to us, okay? So normally when we get title to a property, we're getting legal ownership. Normally, what a buyer is expecting to get is good and marketable title. And that's what a lawyer's opinion usually says, that we're getting good and marketable title. We've searched title and we can confirm that they're getting good and marketable title. So which means that the ownership is free of the rights or interests of other people. And then it might be subject to, maybe there's a right of way or an easement that's been granted, but they still have good ownership of the title. Title insurance changes the opinion that we're giving. When we're giving a title insurance policy, we're telling the owner, and if a title insurance policy has been given to a lender, we're saying that they have good and insurable title to the property as opposed to marketable title. There's a little nuance in that. So I want to explain a little bit what title insurance does. So it protects an owner against losses from existing defects prior to the transfer of title, okay, you know, that were in there that existed at the time the title was transferred, but we didn't know about it, okay? So if after someone acquires title and they put up a fence in the wrong place, or they put up a shed that encroaches on a neighbor's property, or they put their swimming pool up in the wrong place, they're not going to get title insurance coverage for that, but they're going to get coverage for any of those issues if those defects existed at the time of closing and we didn't know about it, because at the time of closing, we didn't have an up-to-date survey. Okay, so the title insurance company will compensate if at any time during their ownership, you buy the policy once when we close the transaction, 20 years later, a neighbor could get a survey of their property done. And it says, oh, you know, by the way, your shed's encroaching, your garage is encroaching on my property. You got to move it. And that'll be thrown to the title insurance company to negotiate that out. And if they have to, they'll move the garage at their expense, okay? Because we didn't know about it 20 years ago when we closed the deal, because we didn't have an up-to-date survey at the time. So that's a risk that the title insurance company is going to take instead of the homeowner. So residential properties, title insurance, I can just tell you for a fact in our office, I should just make this point. On residential transactions, we will not close a transaction in our office, a residential transaction, without getting title insurance. You can, there's a way to do it without, but we won't do it because there are too many benefits to title insurance on residential transactions. So it doesn't make sense. We'll always convince our client to do it. And if they're really insistent, which never really happens, we would send them somewhere else. But they're way better protected if they have title insurance coverage than not having title insurance coverage. So resident, and that's for residential. On a commercial transaction, we look at each one a little bit separately and we weigh the pros and the cons depending on the situation and what information we know about the property and what searches we want to do. Sometimes we get a title insurance policy, sometimes we don't. More often than not these days, we're getting it because there's still more benefits usually than not getting it, but we assess it each time. So there's coverage for residential units, there's different coverage for commercial properties, different processes we go through to satisfy title insurance companies for each of those. So there's potential defects. I want to just give you a few examples of defects. There's liens that we would get coverage for, like that can be registered against houses, condominiums, cottages, even as vacant land. There's encroachment issues that could come up, boundary disputes. Sometimes there's mistakes made in surveys. You know, they make mistakes as well. So and a lot of times there's non-compliance with zoning, and things were built and we don't comply because we're not sending a letter to the building department and the zoning department saying, please confirm that the house constructed on this property complies. When you have title insurance, we're not writing those letters. Without title insurance, we have to write those letters. So one of the big benefits of getting title insurance, in addition to all the coverage for those type of defects, you're also getting fraud protection. So fraudsters are always like, one step ahead of everybody else. But if you have a policy that'll protect the homeowner, so it protects them from someone stealing their identity and trying to sell their property out from under them, or from stealing their identity and mortgaging their property. And we see those type of things all the time. Fraudsters are always searching title of the target properties in particular that don't have mortgages on them. And a lot of empty nesters and elderly people have those type of things. And they're targeting those properties because then they can walk into a bank and say, hey, I want to put a mortgage on this property. We own it free and clear. I don't need 70% of value. I don't even need 50% of value. I just want a little, we want to travel. We want some money. So we want, give us 30% of value. And they go in with fraudulent ID. They get a mortgage granted to them. And most homeowners aren't sitting around once a week saying, hey, we should search title to see if anybody's registered a mortgage against our title. So it could be years that go by before they actually discover that there's a mortgage sitting on their property. So the good news is, for that owner, they'll put it in the hands of the title insurance company. The title insurance company will make them whole, and it's the title insurance company that has to go chase the fraudsters. And they might find them, they might recover, they might not, but they keep the homeowner whole that way. So, and it covers legal expenses, everything. So it's great coverage, and it's amazing how clever the fraudsters are. And every time we have new layers of checking ID and looking for this, it's amazing how they can get fake ID and create fake law firms on letterhead that are acting on these things, and they find a way. So we keep, shutting it down, closing different ways once they become available, and they come up with something else and find a way. So there's certain things that aren't included in title insurance coverage. Like I said before, if it was a known title defect, if it was something that was known to the buyer before we closed, or it was revealed or disclosed before we closed, they're not going to insure over that. So if we discover that there was an encroachment, for example, before closing, then the policy is going to exclude that. Okay, because before closing, if you discover something like that, the buyer's recourse is to go to the seller and say, hey, clean this up before we close. Okay, there's an encroachment here. You got to move the fence. You got to fix the eaves trough, whatever you do, you got to move the shed. If it's discovered before the closing, we got to go back to the seller to fix it. Title insurance is going to cover it. Or anything that's discovered after closing that we were totally in the blind about at the time of closing, that's when you get coverage for it. Title insurance doesn't cover you for environmental issues. And like I mentioned before, it's not going to give any coverage to a buyer who creates the problems after closing. If it's their construction, they put their retaining wall in the wrong place, they put the fence up in the wrong place, they're not going to get coverage for their own actions that way. So title insurance is a premium paid one time when you buy the property. Okay, it's not that expensive. It depends. I'm not putting a number in here because it depends on the value of the property. They charge based on the value of the property. So, and if they're getting a mortgage on the property, then it's the homeowner that's buying actually two policies, a homeowner policy and a lender policy, to give the lender coverage. Because lenders are very happy saying, give us a title insurance policy. We don't need an up-to-date survey as long as you get title insurance coverage. So homeowner pays for both. The homeowner policy is good for as long as they own. It's a one-time payment. It'll cost them $300, $500, $800, whatever it's going to cost them. One-time payment, protect their title as long as they own the property. The lender's policy will be as good as long as that mortgage exists. So if they got a policy for TD Bank today and it's a 3-year term of the mortgage, 3 years later, they go to a different bank, they go to RBC and get a mortgage. RBC will want a new title insurance policy issued to them at that time, and the homeowner will be paying for that lender policy at that time, but they don't have to buy an owner policy again. So it's really relatively inexpensive, and it's great protection.
Question, David. Does title insurance remain valid when there's no mortgage on the property, once the mortgage has been discharged?
Yeah, because it's a separate policy. There's a policy issued to the homeowner. It's a separate policy that's issued to the lender. So the lender policy will lapse, but the homeowner's policy stays in effect until that homeowner no longer owns the property.
Okay. Have a
Okay.
couple of other questions that popped up. Sorry, I had to step away
Yep.
for a few minutes. And if you've
Yep.
already addressed these, please tell me. Squatters' rights. How long does one squat before they get squatters' rights?
Well, that's a good question, and some of that depends on the facts. But there's it's a little different if it's for a right of way or easement purposes, and a little different where you're making a full adverse possession claim, which I believe adverse is 10 years. Like you have to have exclusive undisturbed possession for at least a 10-year period. And that means that the owner that actually owned that property can't have access to it at all. They have, that barrier between the properties has to prevent them from completely going there. So that's the short answer. I think it's 10 years, but I'll have to look that up and verify it.
Okay, so Ruby has a question. I live in a townhouse with no access to my backyard, but through my home. Would there be a right of way built into my legal description to allow me access going through my neighbor's backyard? Oh, to access your backyard through your neighbor's backyard. Okay.
Yeah, if that's the
No,
only
I
way.
always wondered this because I grew up in a townhouse that was next to the end unit. And I remember my parents having to drag the stupid lawnmower through the house and always wondered if they could, if they actually could go through the neighbor's backyard.
Yeah, you'd have to look at the actual legal descriptions of the properties to see what rights you have. Okay, because it's got to be described one or the other. In the absence of it being described that you have that right away, and then you got to take the lawnmower through your house and then get it out to your backyard.
That would be silly to ask your neighbor. Can I take my lawnmower?
The other problem, yeah. The other problem too was
Just
that it was
bringing
all
it-
hills and it was ridiculous. But I remember my dad carrying that damn lawnmower through the house.
Yeah, you might need a front yard lawnmower and a separate backyard lawnmower because once it's there, you're
Exactly,
leaving it there.
exactly.
Okay.
Any other questions, guys?
Well, I'm just going to wrap this up as quickly as I can, then I can take some more questions. So it's sort of the big issue that we get asked all the time is if you have title insurance, does that completely replace, do you never need a survey? Okay. And I would argue that it's still good to have both. Okay. We can close a transaction with title insurance. We don't need a survey to close a transaction. Okay. But that doesn't mean that there aren't some benefits to getting a survey too. Okay, so the title insurance protects you from not having a survey, and it gives us certain information, so we can close our transaction, no issue. Okay, but you as an agent, should you still be asking for a survey? Should you still try and get one? Yes. Should you try and get an up-to-date survey if it's available? Yes. If all that's left that's available to you is an existing old survey from 30 years ago, I would ask for it anyways, because there's certain information that's there and it's still worth having. Okay. So a title insurance policy doesn't show you how far the property is, the house from the lot lines. It doesn't show you where to install fences. It doesn't it'll give you no information about whether you can install a swimming pool or a garage or a hot tub in the future because of where your lot lines are and what the setbacks are. So there still are advantages for surveys. If you're doing any real landscaping, or if you're going to be putting a pool in or making an addition or putting a garage in, then absolutely, for sure, you should be getting a survey done in any event and advising your clients to do that as well. And title insurance isn't protecting an owner for misplaced border fences, party walls, retaining walls that they're party to. So down the road, they're gonna need one anyways. So if there is an existing one, get it. Okay, get it, because even if you have one, now you've got the name of the surveyor, you know who did it. If you want to get it updated, it's easier to go back to that surveyor and say, here's your old survey you did 10 years ago. Can you just update this? That's a less expensive process than getting a surveyor to start from scratch too. So an argument made that they're both important parts of a real estate transaction. They serve different functions. One's not really a replacement for the other. So our recommendation to you out there that are the diligent real estate agents, first of all, know your client, determine your buyer's intentions with the property. If you know they're just buying the property as is, where is, they don't care, they have no plans to do anything, we don't have to worry as much about whether or not we should be looking for a survey before closing. But if you know that their intention is to do some landscaping or put a pool in or make an addition, then it's good to get that survey so we can try and figure out whether they can do it, because maybe it's the wrong property. Maybe they can't do it on that property. So be careful that way. And you've got to look at each situation on its facts. And we do the same thing in our office, whether to advise a client, whether, we're going to be doing title insurance in any event, but should we also be trying to get a survey? And if there isn't one from the seller, does it make sense for us to get a survey done at the buyer's expense before closing? And anytime we know or we have knowledge that they're going to be doing something to the property, that's when they're going to need a survey eventually anyway. So that's the time to advise them they should be getting a survey. Okay. So anyways, I'm here for as long as you need me to answer any further questions, but thank you everybody for attending, and please tune into the defect disclosure one on November 3rd. It's sort of an interesting topic.
Okay, if you remortgage after discharge, but property for some reason is not fit for lender policy, what happens? For example, say 20K new mortgage or property integrity is not great.
Sorry, can you go over that again?
Yeah, okay, so I'm assuming that we're talking about title insurance here. If you remortgage after discharge, but the property for some reason is not fit for a lender policy, what happens? For example, say a 20,000 new mortgage or property integrity is not great.
Yeah, I'm not sure how that ties into today's topic at all, but I think they're saying they got a mortgage. It ran out to 2-year term, 3-year term, whatever it was. It expired, and they're going to try and get another mortgage. And they're struggling because the lenders don't want to give them a mortgage because something physically is wrong with the property.
I'm not entirely sure. Michelle, do you want to unmute and just clarify for us?
Yes, thank you. Sorry about that.
Okay.
So I'm just curious because the title insurance has two parts. One part is for the homeowner and one part is for the lender, from what I gather.
Yes.
So if for whatever reason they've paid off their mortgage, they've discharged, now they want to do an addition to their house. So they go and get another very small mortgage. And they decide, so if they get a very small mortgage, but the original mortgage already had title insurance, so the portion for the homeowner, they don't have to replace that one, but the portion for the lender, they will need to if they're taking out a mortgage with a traditional bank. If the bank decides for whatever reason they don't want to provide them with, I don't know. This is the gray part for me. I'm not sure if anyone will deny giving you the opportunity to have title insurance on a small mortgage of that size.
No, almost all the lenders will give you the option. They'll say, you can either go the survey route, we need an up-to-date survey. And if you're doing that, then you also have to make all the municipal inquiries. We got to send the survey to the city. We got to get clear. If we're not having title insurance, we have to get property tax, certified property tax information for the lender's purposes. We have to make sure we write to the city and send the up-to-date survey to them and get a response that it complies with setback requirements and zoning requirements, that there's no outstanding work orders against the property. So we have to go through that process. So almost all lenders will give you the option of either go through that process or just get title insurance policy for us. So generally it'll be less expensive to get the title insurance policy, certainly less time consuming, and you'll end up with better coverage in a residential transaction. So almost all lenders these days give you that option. Okay. So they're happy to accept a title insurance policy. And while I'm mentioning it, because I didn't really mention it before, but one of the things without title insurance, we had to ask municipality, are there any outstanding work orders against this property? And if we did discover that there was a work order against this property, or it was a non-compliance with the building permit or something like that, then we would go back to the seller and say, you have to fix this before closing. And the seller sometimes can fix it. Sometimes they can't fix it. Sometimes they can't fix it in time. It puts the deal in jeopardy. So with title insurance, we're not even making an inquiry whether there's work orders. We don't want to know. So then we close our transaction with title insurance. Turns out after we close, we find out, oh, there was a work permit outstanding. or an open permit, a building permit that wasn't closed off, something like that. So all we do is we send that on to the title insurance companies here. You guys fix it. You guys clean it up, and they're going to do it at their expense. So anyways, that's just part of the answer. But Michelle, the answer to your situation is almost every lender, I don't know, we're almost never going that route by the non-title insurance route. The lenders will accept the title insurance policy. It's much faster to close a transaction, and they'll take that risk. But it is a new policy issued for that lender. None of that invalidates the original owner policy that was given to the original owner. Now, if that owner is then using that money on the new mortgage to build an addition, and the addition wasn't constructed properly, and at some point there's a work order against that addition, or there's an infraction of that addition, from zoning purposes or setback purposes, that homeowner can't rely on their homeowner's title insurance policy to fix those issues, because those are issues they created during their ownership. It's not a pre-existing issue that was prior to their ownership. Okay, hopefully that explains that for you, Michelle.
Thank you. It does. Thank
Okay.
you.